Good morning, and you're all very welcome to this morning's launch of the Research on Legal Form for Social Enterprises. I'm Margaret Leahy, I'm Social Enterprise Development Manager at Rethink Ireland, and this morning I'm delighted to be joined by Deirdre Mortell, CEO of Rethink Ireland, from the Department of Rural and Community Development, Dr. Andrew Ford, Head of Rural Strategy and Social Enterprise, and Richard Gavin, Assistant Principal Officer. We're joined by Tanya Lalor, Method Communications, who is one of the authors of the report, and apologies from Dr. Gerard Doyle, who's unable to join us. He's the other author of the report. The agenda for this morning is very straightforward. Andrew and Deirdre will launch the report. Then Tanya will outline the findings from the report and recommendations. We will then have Q&A and then some closing comments. Please note for Q&A, put your questions in the Q&A rather than the chat box, and we will get through as many as we can, and I'm sure there's going to be some really interesting questions. Also, please note this is being recorded, and very important that anything that is said this morning or is in the report cannot be taken as legal advice. All social enterprises and those involved in them are advised to get their own legal advice, either from someone they use themselves, or the likes of some companies who provide pro bono work, such as Trust Law, William Fry, or PILA. So, without further ado, I'm going to hand over to Andrew and Deirdre to formally launch the report.
Thanks, Margaret, and a very good morning to everybody. It's great to be here this morning, because it feels like a very important, I suppose, moment for the National Social Enterprise Policy, which was launched a number of years ago as a foundational policy to try to develop the social enterprise sector, both in terms of scale and in terms of impact. And as that policy was being developed, the issue of legal form was already very prominent in terms of being seen as an enabler or a catalyst for development, and indeed as such a catalyst for impact. So I'm very happy to be here. I'm very happy to speak with you this morning, and I'm looking forward to Tanya's presentation and the Q&A afterwards. I want to just start by sincerely thanking Tanya Lalor and Dr. Gerard Doyle for the tremendous work they've done on this report. This is a real national asset now for us in the social enterprise sector. It is the first of its kind, and it really is very instructive and informative. Very high quality research, and considerable amount of work went into surveying and interviewing stakeholders in the sector, which is the most important thing. I also want to thank respondents for taking the time to share their experiences to inform this report, because, as I said, that is critically important. Social enterprises represent a very wide spectrum. From very small scale with potentially a low traded income right up to multinational trading, internationally traded organizations. And that spectrum therefore brings a whole range of different challenges. For some, it might be a matter of survival. For others, it might be a question of looking for equity investment or whatever to scale up. So we recognize that. And I think those voices of the respondents were so important to ensure that the report reflects that. I also want to thank Deckerts and Declan O'Sullivan in particular, as well as the Thomson Reuters Foundation, Trust Law, and Emily Dunnan-Curad for all of the work that they did in facilitating and screening and supporting this independent piece of research that's really critically important. And it is an ideal example, I think, of where government policy, independent legal advice and independent intellectual input can really come together along with the civil society organizations such as Rethink. And with that, I just want to thank Rethink, because that we have a strategic partnership with Rethink Ireland. They are doing tremendous work, not just for the social enterprise sector, but today we care about the social enterprise sector. They are really pushing forward the boundaries in so many ways, and we're very pleased to be working with them and to thank them sincerely for all that they've done on this particular piece of work. As I said, the National Social Enterprise Policy wants to see social enterprise grow both in terms of scale and impact. That's what we want to achieve. We want the sector to be recognised as unique in the entrepreneurship ecosystem, providing scalable impact both in terms of social issues and environmental issues. So anything we can do to improve that, we will pursue and we will do. So from that point of view, the recommendations in the report are really important to us. I'm going to stop right there. I just want to say that it's a pleasure for us from the department to launch the report this morning. And with that, I'll hand over to Deirdre and I look forward to the Q&A. Thanks very much.
Thank you, Andrew. At the risk of a little bit of repetition, I'd also like to say thank you to all of you. You've been called out very clearly by Andrew, but Tanya Lalor, Dr. Ger Doyle in particular, for the really, really hard work. And, you know, I think this was a particularly challenging piece of research to do. So thank you so much. As you can see from the chat, the research is now up on the Rethink Ireland website. So you can grab it and have a look at the same time as Tanya is going to present it. Feel free. I'd also like to thank the Department of Rural and Community Development, Andrew and Richard and your colleagues for co-funding this. And I think, you know, at one level, money is money, but actually combining private sector and public sector money to fund a piece of research like this, I think is a really important move symbolically in terms of the importance of social enterprise, that it's not just a little niche thing that's of relevance to a couple of communities or a bit of the public sector or whatever, but it's actually important to the whole of Ireland. And I think, Andrew, you put it very well in terms of saying this is a unique part of the entrepreneurship ecosystem in Ireland. So, you know, I do actually think that the symbolism of co-funding something across sectors is very important. So thank you for doing that with us. Thank you also to Deckard and Thomas Reuters Foundation in particular for providing the legal screening, which was really important and which they provided pro bono through trust law. So thank you very much for that. Another piece of cross-sectoral collaboration. And finally, I'd just like to say, Tanya will present the research in a moment, but I think, having had a chance to read it, that, you know, we really are at a milestone. This is a really significant milestone, this piece of research. And you know what? It answers a lot of questions, but it raises just as many questions for all of us who care about the social enterprise sector. So it's not going to give us a beautiful silver bullet for what is the answer for, you know, what is the right legal form here. What it is going to do, I hope, is provoke a debate across the whole sector. And we really need your feedback in the next stage to help us all think about what next year. So with that, I would just finally also like to thank the Rethink Ireland team who worked on this, Owen Ryan and Sarah Hoffmeyer, who've put in lots of work behind the scenes. And we look forward, Rethink Ireland continues to be committed to the social enterprise sector and the development of the ecosystem in particular. So we're really looking forward to the next stage that develops from this. So thank you so much.
Thank you, Andrew and Deirdre. And as you say, a lot of debate, a lot of questions, but it's fantastic to be at this stage and have the research findings available to us. So I'm now going to hand over to Tanya to do that, to set out the research and the findings. And just to remind everybody in the chat, the hashtags are there. If you're a Twitterati person, please feel free to tweet away to your heart's content. And I will now hand over to Tanya, and I'm really looking forward to this.
Thank you very much, Margaret, and everybody. And I hope the presentation does justice to the research. I'm going to just share my screen now for all to see. Okay, so I suppose in terms of preparing this presentation, it's a short enough presentation just to go through some of the summary of the findings and the recommendations. And I suppose in saying that, what we were struck in doing this research is that the issue is really multifaceted. Many, many layers of issues and discussions arose in the research. And in many ways, it goes to the heart of many of the issues around the development of the sector. So you won't get all of that from the presentation, but hopefully by reading the research, you'll get a better sense and a more comprehensive sense of the wide range of issues. So you can see there in the first page, context and methods, just by way of background to the research, the key findings and the summary recommendations. So I'm just going to go to the first slide. And I suppose the context for the research, as mentioned previously, was the issue of legal form arose in the research that gave rise to the National Social Enterprise Policy. And then as a result, it was exploring the issue of legal form was one of the actions in the policy. Specifically in relation to this research, there were three main research questions. What barriers are experienced by social enterprises in Ireland as they relate to legal form? Would a dedicated legal form benefit the sector? And if so, what form should it take? And would a legal form be necessary for the sector? And I'll try to go through all of those this morning. The methods then that we undertook in terms of the research was, first of all, desk research. We surveyed social enterprises and had got a response, 79 responses from social enterprises in the sector. We carried out semi-structured interviews with 32 individuals from 27 organizations, and 10 participants took part in 2 focus groups. So I'm going to talk about the survey findings first, and I'm going to quickly, before going into that, give a very quick overview of the profile of respondents. In relation to existing legal form, 72% of social enterprises were registered as company limited by guarantee, and other forms of legal form were used by others, including co-op, including a small number of company limited by shares as subsidiaries of company limited by guarantee, etc. 73% were standalone organizations and were not part of a parent organization. 71% had been trading for more than 6 years, and 27% had a turnover of less than 50,000 euros per annum, and 21% then had a turnover of over 600,000 per annum. So reflecting the diversity of the sector in terms of very small social enterprises and larger social enterprises. We asked a question in the survey as to whether respondents had applied for charitable status, and at least 60% of them had applied for or had gained charitable status and were charities. And I say at least 60% because some people, in terms of describing, had described their form and their structure as hybrid social enterprises. And in some ways, having charitable status and being charities was conflated with legal form. And of course, charitable status is not a legal form. So the actual figure of those who'd applied for charities would have been slightly higher to account for that. And the reasons organizations had applied for charitable status, we asked them to rank from a series of 4 options. The first most prevalent one was to access grants or social investment funding. The second to safeguard social mission. The third to gain charitable tax exemption, and the fourth to safeguard the reputation of the organizations. And we'll see why charitable status was so important as an issue arising in the research. We asked respondents whether they believed the current legal form that they use met their future needs. 59% believed it did, 25% said it didn't, and 16% had no opinion. And if the legal form didn't meet their future needs, the reasons were that one was the inability of managers, who in many cases were also founders of social enterprises, to participate in the governance structures. And that's related to charitable status, whereby directors are not permitted to financially benefit. And so that precluded many people who were founders to actually take part in governance structures. We'll come back to that again in a little while. Funding constraints was also an issue, whereby charitable status was perceived to be an expectation, and in some cases maybe a real requirement for some funding, but for others, having charitable status was ineligible for other forms of finance, which was an important issue which arose. The legal form for some didn't meet future needs because it limited the ability to access private capital and equity finance, and therefore to issue shareholding. So obviously, company limited by guarantee would have no shareholding element to it, and that presented a barrier for some, particularly in relation to scaling. The other issue was lack of recognition. So, for example, if some social enterprises were not registered as a charity, they felt that there was an issue in terms of being recognised for their activity. And then the other burden, I guess, was the compliance burden. And there was a view that the requirement for compliance, either from charitable status or company or just regular by company law, was a burden, and which was a disincentive for many people to become directors, particularly of social enterprises, and that was an issue. We asked also the question as to whether people felt that there was a need for a dedicated legal form for social enterprises. And 69% believed there was, 10% said that there wasn't, and 23% had no opinion. And some of the reasons here, which arise as well in the themes of the wider discussions in the research, was that there was a need to define and clarify the sector. In some cases, people felt social enterprise didn't really have any, it was very broad. So having a dedicated legal form would in some way regulate what is and what isn't a social enterprise. And for some, that was important. For others, a dedicated legal form would be able to facilitate a governance structure where the manager could form part of a decision-making structure, as mentioned before, particularly in relation to charitable status more than legal form. Managers cannot participate in that decision-making structure. And that again arose in the wider discussions. We might talk about that a little bit in a while. The other reason that people felt a dedicated legal form was important was as an alternative to charitable status. So for those for whom charitable status was not appropriate for, there was still a need to safeguard the social mission in the form of an asset lock. An asset lock, of course, is a requirement of charitable status, but not a requirement for organisations that are registered as a company limited by guarantee. And just, I suppose, what an asset lock means is that the assets of the social enterprise cannot be distributed freely if there is a dissolution of the organisation or the social enterprise, the assets must be transferred to a similar organisation, or in the case of a charity, a similar charity. The other need was to allow shareholding, again relating to the constraint above, to allow access to equity finance and investor capital. And also a dedicated legal form would provide recognition of the sector, for example, within state organisations as an alternative to charitable status, and it should allow tax advantages for social enterprises. It should alleviate the compliance burden, as mentioned above, and it should allow payment to directors. Now, this was in addition to a manager or an executive forming part of a decision-making structure. This related more to about being able to recruit professional directors and access that type of expertise to the board of social enterprises. And so I put up this slide because one of the questions in the survey asked people as to what features should a distinct legal form include. And this was the responses of those who felt that a dedicated legal form was needed. And so you can see there, if you look at the responses there, I think this is a really telling slide because it shows where there is consensus in some issues, but there isn't consensus in other issues. And so this became quite a dominating theme in some of the later discussions of the in the research. So for example, there you see the big blue bars where people, for example, 95% believe that the features of a distinct legal form should ensure that the assets of the social enterprise are dedicated to social benefit, for example, the asset lock. So 95% you can say consensus there. 99% believe that it should, a dedicated legal form should require annual reporting of social outcomes. And to a large extent, 81% over to the right-hand side, pretty much consensus there, you could say, or certainly a dominant view that a dedicated legal form should place limits on the distribution of surplus or profits. However, in relation to some of the other ones, there isn't a consensus. And with regard to the question, of facilitating private shareholding, a majority of respondents believed that a distinct legal form should not facilitate private shareholding. And that's significant because the need to facilitate private shareholding was one of the rationale and the reasons why a distinct legal form was believed to be important for some. The second issue there in relation to the responses was that 73% felt, the one in green there, the fourth one across, that a distinct legal form should not enable directors of the board of a social enterprise to financially benefit. So if that was the case, if that was not a feature, that would impact on the issue of managers and the executive function being part of the decision-making function. So I think that's important because it demonstrates, even amongst people who feel that there is a dedicated legal form, there's a wide range of issues and there isn't consensus among some of those issues. And this was a theme arising in the research. So just looking maybe at some of the other themes that arose, I suppose the issue of identity, clarifying purpose and putting boundaries on what a social enterprise is often a rationale for putting in place a distinct legal form or any legal form. And that idea of signaling what you are and signaling what your intentions are in the form of a legal structure. And there was in the discussions, and particularly the qualitative and interviews and the focus groups we held, there are different interpretations of social enterprise. And some people felt that there was a need to place boundaries on social enterprise, that there's a risk that it can become a catch-all term, that it can be, I suppose, conflated in some ways with corporate social responsibility, and that needed to be clarified. There was also a view amongst a number of people that we interviewed that we need to embrace in Ireland, particularly more of the participatory aspect of social enterprise, and to go beyond just the service delivery and to include more models and more practices, I guess, of inclusive governance, which will be included in more kind of European definitions or models of social enterprise. A counter view to this was that it's too soon in the sector's development to place boundaries or to kind of define, if you like, social enterprises, and that the broad national definition of social enterprise in the policy is appropriate. And to that, another view in relation to that is that legal form or any form should follow function, and that we weren't there yet in terms of what a social enterprise is and how social enterprises will evolve in Ireland. The second issue as a theme which arose in the research, which we've spoken about previously, is that issue of recognition and validation. And this was strongly linked to the issue of, or the perception that it's important to have charitable status if you are a social enterprise. And for many people, it's important to validate the credentials of social enterprise. And one option of doing this is to establish as a charity and to gain charitable status. But this is obviously, this was not so much obviously, but this was problematic for other social enterprises. And this was the idea that there was a perception that there was an expectation of some funders. In some cases, this has been made explicit by some funders that you have to have charitable status in order to avail of funding. But at the same time, having charitable status meant people were ineligible for other forms of particularly enterprise funding, that people felt that there was a problem in relation to that, probably more to do with awareness around policy of organizations and perceptions rather than to do with legal form. And then in terms of the charitable status, the reason charitable status for many organizations was not seen as relevant to their social enterprise was the fact that the founders of the social enterprise that would have maybe gone on to have an executive function or were managers had to make a choice between being in a paid function in the social enterprise and participating on the decision-making structures, particularly where those individuals were founders. I have to say as well, there wasn't consensus on this point either, because there was also a relatively strongly held view that it isn't good practice to have managers participating on decision-making structures. It's not good governance, and that there should be a separation of function in that regard. And also it could lead to very kind of manager-dominated boards as well. So that was also an issue rose. And then the other issue in relation to accessing specialist legal, or not legal expertise, but the ability to access expertise through paying directors was an issue that we've spoken about before in terms of the barriers that charitable status prevents that, and yet it is regarded as being important for many social enterprises. So some of the other issues that arose in the research were to do with life cycle issues. Some of these were to do with support and the burden of compliance and liability. The point was made, especially for startups, for new social enterprises, and also to encourage people to engage in the sectors and to establish social enterprises. The immediate compliance issues that arise when registering as a company, not related to charitable status necessarily, pointed to issues around the need for support, incubation support for new social enterprises, and for some people a sort of a graduated compliance and reporting function that could be linked, for example, to turnover. As turnover increases and social enterprises got to a particular size, maybe a degree of compliance will be linked to the size of turnover. In relation to this, of course, there wasn't an overall view in relation to this consensus. Some people felt that some social enterprises are not great on transparency, and some people pointed to the fact that many social enterprises don't publish or only publish abridged accounts, for example, and that was an issue around transparency that people raised as well. In terms of scaling, the issues here included access to private equity finance, as well as separating from the parent organisation. So, for example, in relation to shareholding, company limited by guarantee does not facilitate private shareholding, and so when a social enterprise that wished to access equity and equity finance, they tended to establish subsidiaries as company limited by share. So if, for example, the designated activity company with shareholding was one option, or company limited by share was another option that a social enterprise would form, which would allow shareholding. And the problem with this for many social enterprises that had adopted that form was that they felt it was viewed as suspicious by state agencies. It was a complex structure. There were many legal costs associated by that, and that there was a nervousness and a suspicion as to why multiple structures were being formed. So that was a problem. Some social enterprises felt that it would be beneficial to have a legal form, even when looking at shareholding company structure that would have an irreversible asset lock. Of course, you can put in place an asset lock as part of your constitution, but that it would be useful if there was one that was a part of the legal form that couldn't be reversed. Another issue in relation to scaling issues, not so much in terms of shareholding, but just in terms of separating from the parent social enterprise. Some social enterprises were established by wider organizations. So there was a trading aspect to the organization in the form of the social enterprise, but that might have been part of a wider just general voluntary sector or community organization. And the issue of kind of perception or the attitudes of state agencies arose here. And in the case of one social enterprise, they wanted to establish a separate legal entity, not necessarily a company that was had shareholding, but a separate one for reasons of risk, to separate the trading function to the other organization's functions. But they weren't able to do this because funders had said, we already have a contractual agreement with the parent structure. We don't want to have a separate contractual agreement with another legal entity. So that actually meant that they couldn't establish a separate legal entity, which wasn't necessarily good practice and exposed the other organization to risk. So I suppose here, in terms of looking at life cycle issues, there's two arguments here. Number one, the issue is about policy and awareness rather than legal form. And then the other argument is that a fit for purpose legal form would alleviate all of these issues and would provide for future-proofing the sector. So two perspectives within the scaling issue. Another issue that arose was that legal form, that to be careful of the fact that legal form cannot be a proxy for social impact. And I suppose I have a quote here that somebody mentioned, that you can do what you like with legal form. So while you might have all the restrictions in terms of distribution of assets, asset lock, etc., the point was made by a number of people that you can still have bad practices in terms of, and so, you know, you might have very highly paid staff while other staff are on very low wages, and that legal form shouldn't be seen as a proxy for social impact, and social value still needs to be demonstrated. So there was a kind of a strong argument as well in the discussion that there's an issue in terms of certification standards for the sector, and that standards for the sector was an important was an important issue, in addition to, or in some cases, instead of legal form. And we spoke to people in Europe as well, organizations where this discussion is playing out as well. Another view that arose was that there's risks associated with having a dedicated legal form. And the point here was made was that if you have a dedicated legal form, that might become the expected or the default structure for social enterprises, and that those that don't adopt that model might be questioned as to why they wouldn't. So it may not fit all. So I suppose if we go back to the 3 research questions, just kind of summarize some of the points here. What are the barriers experienced by social enterprises in Ireland as they relate to form? Lack of recognition is one of the barriers. They relate to legal form insofar as sometimes there's an expectation that certain legal forms are adopted by social enterprises by state agencies, or there's a nervousness about certain legal forms. And that might be really relating to limited awareness or acceptance of social enterprise and all its configurations as a legitimate activity for funding. The other barrier identified, and I think this was significant and it arose continuously, is that whole issue of charitable status as being a requirement to gain support from some funders, which presents difficulties in that it's not always an appropriate model for some social enterprises. And we've spoken about the reasons why that might not be the case. And then at the same time, having charitable status might preclude social enterprises from gaining financial support from elsewhere. Compliance issues then that arose from legal form, which can act as a disincentive for voluntary directors or for promoters of new social enterprises. And that applies to early scale or early stage or small scale social enterprises in particular. And that may be a support issue around supporting for social enterprises. And then finally, the point there around difficulties in securing equity finance arising from the company limited by current guarantee legal form, as this does not facilitate private shareholding, i.e. having no share capital. And so then the next question, would a dedicated legal form benefit the sector? And if so, what form should that take? And I suppose the point there is that a dedicated legal form would lead to recognition of social enterprise as a legitimate form of enterprise, which is distinct both from the private sector and for the broader not-for-profit sector. A dedicated legal form would provide an alternative to charitable status, which would establish the sector's credentials among funders, establish trust with stakeholders, and would safeguard the social mission of the social enterprises. And then another benefit then would support the development of the sector through limiting compliance requirements for voluntary directors. If there were specific and a kind of a light touch, I guess, regulation or lesser compliance regulation, as has been the case in international models, for example, community interest companies, et cetera. And this would also facilitate the scaling. And there was a view that the above benefits would attract individuals to promote, develop, work in, and volunteer in social enterprises. A counter view as well that a legal form might not benefit the sector, as it would involve placing boundaries on a sector which is evolving and where there are very different views on the concept of social enterprise and the principles underpinning it. And that we've mentioned again that a default legal form could present a risk of becoming, or dedicated legal form could present the risk of becoming the default or expected legal form for social enterprises, and that if you didn't adopt that legal form, you might be disadvantaged in terms of recognition. Kind of in many ways in the same way that people are of the view that by not having charitable status, that you can be disadvantaged in terms of that recognition. And so the question in terms of the legal form that it could take, just some points here, and it's explored more in the research itself. There was a view that it could adapt from the cooperative model. In many European countries, social cooperatives and kind of dedicated legal forms are kind of based on the cooperative model. And people spoke about the underuse of the cooperative model here, the opportunities that that model could have to address some of the barriers people identified, and the need for, especially given the legal review or the legislative review of the cooperative model, that there's an opportunity for that. The predominant view, though, was that community interest company, using the example in the UK, was a predominant view as to what form it could take, and certainly some dedicated legal form arising from company law. There was a consensus, as we've seen before, around limitations on the distribution of profits and an asset lock, but crucially, divergence around issues to do with private shareholding in relation to equity and the ability of board members to financially gain, as we saw in the slide. So in terms of the other question, would a dedicated legal forum be necessary for the sector? That's very difficult to know at this point in time, because many of the barriers are associated less with legal, or not exclusively with legal forum, but with regard to policy, funders policy, recognition, governance, and awareness issues. There's also a view that irrespective of legal form, there's a need for standards, accreditation, and certification for social enterprises. And also, in terms of the necessity question, the fact that there is a significant divergence of opinion about the characteristics of a dedicated legal forum means that there are questions that remain about what form, what features a dedicated legal forum should have. And so here's a slide which is included in a table, rather, that's included in the report, and I'm not going to talk about it for any more. I'm not going to go into it in any detail, but what we did here was, on the left-hand side, we identified some of the issues that arose in the research, and identify how those issues, or whether those issues, can be facilitated within existing legal forms. And the legal forms that we have referred to there are company limited by guarantee, company limited by share, designated activity company, and IPS, which is cooperatives, and charity status, of course. And of course, charity status isn't a legal form, but the provisions that charitable status include were specified there. And I suppose you can read about this and have a look at it in the report in your own time. But I suppose the point there was made was that as some of the issues are less to do with legal form and more to do with charitable status, we want to make that distinction as to what can and cannot be facilitated within current legal forms. And then the recommendations. I suppose the first one is to support social enterprises to maximize the use of current legal forms, and that their clarity would be beneficial around the use of legal forms to provide for the features identified in the research. And so, for example, we recommend that there should be more use of model rules for all company forms, and that guidance and model rules should include provision for the use of subsidiaries and holding company models for multiple activity social enterprises, and particularly for social enterprises that are looking to establish subsidiaries that have a shareholding to allow equity investment. Because even if there is, if there was to be pursued and developed a dedicated legal form, that's going to take time, and there are immediate needs in relation to these issues. Also, that organisations like ICOS, the Irish Cooperative Organisation Society, should highlight the advantages of the cooperative model and support social enterprises in its use, because there was a view that co-ops are little awareness around it. They're seen as rather complex. They can be seen as archaic, and there's a body of work to do there. The other issue is that this issue of the perception or the requirement that charitable status is required in order to avail of certain public funding programs, or that is a barrier to others, is an important issue and is a significant barrier, and that there's need for ongoing awareness raising and training activities in relation to eligibility for funding for social enterprises, and in relation to that social enterprise enterprise funding bodies, but also wider funders and public bodies, including the HSE, Department of Social Protection, local authorities, and others. The rest of the recommendations is that there really is, I think, a need for sector-wide discussions on these issues of identity and principles and criteria of social enterprise towards a shared understanding about social enterprise to accommodate the perspectives raised around identity of the sector, because legal form is very much about identity. It's very much about signalling what the social enterprise sector is, or can be, or should be. And it particularly arose in the kind of wider discussions. There is a divergence of views as to what is in and what isn't in, or what should be and what shouldn't be regarded as a social enterprise. But there's also recognition that there's never going to be, we can't expect to be consensus and have achieved consensus in that regard. Again, the other point, there is a need for some sort of a standard or a certification aside from legal form for social enterprises, particularly those for whom charitable status is not appropriate. And in regards to those social enterprises, the issue of where many applied for charitable status as a reason, as in order to gain tax exemption, consideration should be given as to how specific initiatives and exemptions, including tax exemptions, could be used to apply to social enterprises, regardless of their legal form, in the same way, for example, that sporting bodies can achieve of certain tax exemptions. In relation to the support issue, incentivizing and supporting social enterprise activity, particularly for early stage social enterprises, an incubator type of a model of support for early stage social enterprises prior to legal incorporation, as well as supports around amalgamating or merging social enterprises to support the scaling of the sector should be developed. And this is in addition to models around and supports around equity finance and so forth, which is the second last recommendation. So those social enterprises that are currently scaling and currently require private equity investment, there should be models and support around using existing legal forms, for example, the DAC form or company limited by share with share capital. The issues should be explored and documented, and consideration should be given to applying legal resources to this and legal advice to social enterprises which are actively pursuing these forms of finance around how they could be facilitated to do that within existing forms. And then finally, the needs of social enterprises that arise from their legal form and their existing use and their current use of and their effective use of current legal forms should continue to be monitored and explored. So that's it. That's all the slide, all of the slides. So thank you very much. Looking forward to hearing people's feedback and questions. Thank you.
Thank you, Tanya. That was a really good presentation, and some really interesting stuff came up there. The questions are coming in hot and heavy, I can tell you. But just one thing I would like to mention in relation to your recommendations, and coincidentally, the Irish Social Enterprise Network and Rethink Ireland were separately working on a piece of work around constitutions, and we've now actually combined the two pieces, and we're looking now at a CLG model constitution. So that's just something that we're working on together, which came up in your recommendations there. So the questions and answers now, I'm being joined by Richard, Andrew, and Tanya. And the first one is for you, Tanya, and it's kind of like a factual one. And they want to know if industrial and provident society aspect was covered in the research.
Sorry about that.
Okay.
Yes, it was covered in the research. I think in terms of the respondents, the surveys who were co-ops, I think about 5% of them were incorporated as co-ops. But of course, some organizations that adopted cooperative principles were registered as company limited by guarantee. They used the form of company limited by guarantee to incorporate their co-ops. And it did, and there was a view that the co-op function, the co-op model was underused and it should be used to a greater extent. So there was a view in relation to that. Came up more in terms of the discussions that followed, the qualitative discussions, because of course in the survey, the co-op form wasn't dominant, but certainly people felt that the model of the legal form and the model of a social co-op, as is used in Europe, is one that could definitely have application here. So I suppose the answer to the question is yes.
Great, thank you. Now, I have to say, and this is probably no surprise to any of the panelists, we've had a lot of questions in relation to charitable status. And whether it's a hindrance or a help, and particularly in relation to funding and that. So this is quite a big question, and maybe Andrew, do you want to address some of the issues around charitable status?
Yes, it is a very, very complicated issue. I think look, this is really a multifaceted question, because the charitable status issue has relevance to the issue of access to grant supports. It has issues. It's related to identity. It's related to regulation. It's all of those types of things. So there's no easy solution here. I can say, though, just from my observation, one step removed, as it were, that I'm not sure the default to charitable status is necessarily helpful for the social enterprise sector. I would probably go so far as to say it's tipping on being unhelpful, because there's the social enterprise business model is a business model where there is a trading and ongoing trading element, in parallel and equally important to the social mission, because it is, that's what facilitates the impact. And there is a challenge, I think, in overcoming the perception that it is okay to be a trading entity and a social mission focused organization, particularly if you have a charitable status. So look, I Margaret, I'm not sure I can go much deeper on it, to be honest with you, other than saying simply that I think that the default to charitable status is not always helpful. I think that there are certainly a range of options out there that maybe ought to be considered, and certainly the recommendations that Tanya and Ger have outlined are going to be very helpful, which we'll be given very careful consideration to see how we can address, and many of which we are already looking at. But I would actually be more, I suppose, interested and optimistic about the review of the cooperatives legislation. I think that is actually the light at the end of the tunnel potentially here, because that Industrial Provident Societies Act from 1893 or whatever it is being reviewed at present and is tackling head on many of the issues that are relevant to social enterprises and others. And it is a mammoth piece of work that has been, I think, progressed and had some, obstacles along the way for many years, but now it seems to be on the track to coming to fruition. So I think it's something that we really need to keep focus on and see where we go. But charitable status, it's a matter for organizations to decide themselves, obviously, but my gut feeling on it is that it may be impeding the development of the sector by having this default approach of seeking charitable status for social enterprises.
Thank you, Andrew. Here's one I'll open up and you can decide who wants to take this one. There is talk about certification or standards for social enterprises. And I'm also conscious that in the report, Tanya, people talked about the onus already on governance and the amount of work to function as a company and everything else. So is there a need for certification and standards? And is this putting more work burden back on particularly startups and smaller mid-sized social enterprises? And jump in, whoever wants that one.
I suppose there was a number of issues in relation to that. And first is that issue was acknowledged by people. And that on the one hand, you're talking about kind of, establishing your credentials and even like in terms of reporting on your social outcomes, that is an issue of accountability, and that is an issue of compliance, and the burden of having to do that. And I suppose in a sense that there was, what the research demonstrated is, on the one hand, legal form needs to be fairly flexible to accommodate the needs of social enterprises. But at the same time, there needs to be, whether it's a formal certification, some people felt that there was a need for formal certification, but definitely criteria or an agreement as to what are the principles of social enterprise. Some people spoke about, for example, the Eames criteria have social criteria and economic criteria, and they're included in the appendices of the research. And there was a sense that there needs to be a clarity as to what we mean by social enterprise, and that either standards or principles or criteria, and they could be funder criteria, they could be established by individual funders, but that it was important in some way to place a boundary on what social enterprise is, because some people made the point that it can be very much a catch-all term, and that the point was made that all enterprise has a social impact. You're providing employment. It's a good thing, and so it's important not to. It's important that I suppose to in some way safeguard the unique principles of social enterprise, and some people had different views as to how that could be achieved or implemented. So I don't know if that answers the question. Probably doesn't, but I guess that there are complex issues around compliance and standards and certification and validating and safeguarding those principles, I guess.
Margaret,
yes.
could I come in there just to add something? This is a bit of a double-edged sword. There's definitely value in identifying, in being able to immediately identify which organization is a social enterprise and which is not, which meet a criteria or a threshold, which aspire maybe to being social enterprises, and which don't. That would be incredibly helpful for all sorts of reasons, for public procurement, for just general market development, for just identity, for all kinds of things. On the other hand, we also have to be careful what we wish for, because on the other side, one of the big findings from this report was what we've heard across the charity and community voluntary sector at large is around compliance and regulation and the administration burden associated with good governance and all of that. So we do need to be cautious about balancing those things. Now, I think there's some really interesting stuff happening. I mean, if you look at what Social Impact Ireland are doing at the moment around the social enterprise mark, that's really, really interesting. They're doing a pilot where they are really tackling this issue head on to try to find a way. Can we give this mark to a social enterprise where people do understand that these organizations reach a certain threshold, a certain standard, and that gives confidence to the market and so on. So I think that is one to watch. But as I said, we just need to be careful a little bit what we wish for.
Yeah, I think that's a really important point. As I say, particularly for startups or those, with small number of employees, the admin burden can be quite intensive. But also, as you say, having a way of identifying them. And a lot of social enterprise nowadays, part of their marketing strategy is to say they're social enterprises, because I think people more and more want to spend their money in a responsible manner. So I think it's getting that balance is really important. Just again, back to Tanya, a factual question, or I think she wants to know were the views of the Companies Registration Office, the Registry of Friendly Societies, and the charities regulators sought during the research, Tanya?
Yes, and we spoke to the Department of Enterprise in relation to the changes in the proposed review of IPS law in relation to that. I suppose the position of the Companies Registration Office is that they're a registrar, as opposed to having an opinion on legal form. But yes, I suppose the answer to that was, and we spoke to the charities regulator as well.
Thank you, Tanya. The questions, I mean, there's so many questions in relation to the charitable status and the separate legal form. I suppose one of the things is, I think we all need to take time to look at the research and read it. I'm sure Richard and Andrew have. And, is there any overall closing comments? I mean, unfortunately, we are coming to the end of this, by the way, but overall, Richard and Andrew and Tanya, would you have some closing comments to make on where we go from here?
I suppose, sorry,
go ahead, Tanya. Yeah.
Go ahead, Tanya, go ahead.
No, we were just very struck by the research sought to answer 3 questions about legal form, and it raised more questions than it answered, really. And so I suppose I think that there's a lot of discussion and, in relation to the issue. So I suppose that was just an observation that we couldn't actually answer the question, particularly, it raised more questions than it answered. So that would just be my observation on it.
Thank you, Tanya. Richard, you want to come in there?
Yeah, just in following what Tanya said, a lot of issues raised, and to deal with them, like, we're continuing to engage with different government departments, Enterprise Trade and Employment, Enterprise Ireland, the LEOs, and also the charities regulator. I mean, that's been mentioned, and it's fair to say a lot of social enterprise will continue to go down that road to register as a charity, and we're engaging with the CRA on, I suppose, improving awareness themselves of the needs of social enterprises, but also paying adherence to the Charities Act and ensuring that they can comply with the Charities Act requirements.
Thanks, Richard. Actually, that was one of the questions I had hoped to get to, but I wasn't, about that cooperation there. So that's really important. Thank you. Andrew.
Margaret, just a couple of points. Just to simply say again that this report is incredibly helpful for us and useful. And I think it's the right time to start this conversation in real detail. Like, we are coming now into the last year of the National Social Enterprise Policy. Over the next 12 months, we need to have a conversation about many of the questions that were raised. Are we content collectively as a sector with the definition that's provided in the National Social Enterprise Policy? Are we content with the direction of travel? Should we be reprioritizing in different directions? There's a huge amount of support that's being provided by our department and others for social enterprise, but there's never enough, and we need to be mindful that we have to prioritize which direction we want to go. We have a number of schemes open at present. Maybe Richard might say a word about that in a moment. But I think that the fundamental questions around what the social enterprise sector looks like, what are our aspirations for the future, and I also think that on the other hand, it's really important that if we're going to work to developing this sector into a really innovative, impactful sector, which it is, and it can be a lot more, we also need to pull together. All of us, I mean, both individual social enterprises in terms of marketing themselves as social enterprises. If they're not calling themselves social enterprises, what we all do here is completely and utterly futile. So that's a really important point. The other point I would make is that it's really important that we all work to professionalize the offering, because all the work we do on public procurement and so on, it again will be for naught if we don't ensure that the market is ready. And I use these terms deliberately because, what I've heard over the last number of years with the department is that that social enterprises are hungry for business supports, and they're hungry for market access and so on. So all of this kind of language, we need to ensure that we normalize it. But look, just to simply reiterate, we are thrilled with the report. We're going to work through it very closely. We're looking forward to working with all our partners on it. And again, our door is always open. If we can do things better or differently, please give us a shout.
Thanks very much. Thanks, Andrew, very much. And just a quick note, a reminder from Descartes that there is legal support available pro bono from PILA sponsored program for those listening. Richard, you have a few quick updates for us on the sector, please.
Yeah, Margaret, thanks. And one of them is related to awareness raising, which of course was raised many times in this report. We have a scheme open at the moment called Arise, Awareness Raising Initiative for Social Enterprises. It's open to social enterprises and to network and support organizations. The closing date for that is the 20th of October, so there's still time to get applications in on that. Secondly, there's a capital grant scheme for social enterprises, which has been run by the LCDCs. Some of them are still open for applications. So if there's any social enterprises around the country, just contact your local authority to get further details on them. And finally, save the date. Our third National Social Enterprise Conference will be on the 18th of November. So save that date, watch our Twitter feed, and we'll be providing further details on that shortly.
Thank you very much, Richard. And with that, I would like to thank Deirdre, Tanya, Andrew, and Richard for today. To Deirdre and her and Gerard for the actual research report was fantastic. I'd like to thank all those who attended today, to the respondents, because without respondents, we don't have any findings in research. And my colleagues, Sarah Hoffmeyer and Ellie Morrissey, who were doing backroom stuff today, and the logistics and IT provided, as always, by Sam Whelan-Curtin in his usual expert way. So, Míle buchas to everybody, and have a good day. Slán.